So without further ado, we are going to move right into the presentation topics here, and we will get right into the topic about vaccination policies, employee terminations, and the eligibility for employment insurance. And there's my contact information. Okay, so quick background here about vaccination policies. Vaccines against COVID-19 do provide protection against disease, in particular against severe outcomes. The vaccines that have been authorized for use in Canada have been proven to be safe and effective. There have been some myths and misinformation that have been abounding. I'm not going to get into them today, but they have essentially been debunked. Now, employers also have a statutory duty to protect the health and safety of employees, and this duty is set out in the Occupational Health and Safety Act. So employers should look at mandating vaccination as one way to meet this duty. And I say one way because it should also be combined with other public health precautions. So things like we're talking about hand washing and physical distancing and masking and so on. And when determining the nature of a vaccination policy, it's important for employers to consider the specific and unique challenges that their workplace faces. So in other words, and we'll get to this later, this is not a situation where a one-size-fits-all policy is generally going to work. So employers can become exposed to legal liability in a number of situations. So the first is if they don't take reasonable steps to prevent COVID-19 infections in the workplace. And we're talking in particular if an employee develops a severe outcome or dies and can show that they contracted COVID because the employer did not take reasonable steps to protect them. Employers could be liable if they don't accommodate employees under the Human Rights Code. So we're talking about medical and religious possible exemptions here, although they are rare, they do exist. And finally, employers can get into trouble if they do not take proper steps to safeguard employees' personal obligation or personal health information rather. So we're talking about things like their vaccination status or a copy of their vaccination receipt. Health Canada and NACI are very pro-vaccination, and in fact, the courts have taken judicial notice that medical authorities recommend vaccination. There's a couple of cases there which are cited here on the slide. Now, there are some people who will not be able to be vaccinated or would be entitled to exemptions under the Human Rights Code. So again, religion or disability, and others continue to remain unvaccinated for personal reasons. Dr. Davila, back in August of 2021, made this statement that is very pro-vaccination and encouraged employers to have workplace vaccination policies in the interest of health and safety. And the courts have also found that medical officers, such as Dr. Davila, should be afforded what they've called significant deference here. So when we're dealing with vaccination policies in the workplace, so we're talking about policies that require employees to get vaccinated, basically you're balancing the interests of health and safety on behalf of the employer, that those obligations have to be met, with an employee's human rights and other interests. And if an employer policy unreasonably infringes upon the rights of employees, the policy may not be enforceable at the end of the day. And if an employee is terminated based on a breach of that policy, then the employer may end up being liable for severance. Now, when we're talking about terminations, the courts will eventually be asked to draw the line in terms of what's reasonable and what's not, and what terminations for cause should be upheld and which ones should not. However, we do have the benefit of a number of labor arbitration decisions, which do provide us with some insights as to how the courts might rule. So We know that arbitral awards are highly contextualized, so really it's the facts and circumstances that matter. And we're talking about factors like the nature of the business, the type of workplace, the kinds of services offered, the characteristics of the employees, and other specific dangers or hazards and how they might interfere with the employer's business. And these things will change as the pandemic continues to change. So in order for the policy to be enforceable, basically it needs to be reasonable. It has to strike an appropriate balance between both the employer's interests and the employee's interests. And it should be custom tailored to suit the parameters and realities of the workplace. So in other words, it's not necessarily going to be a policy in which one size fits all. So let's look at some of the decisions that have come out in the labor world. And there are 4 types of COVID-19 workplace policies that have been considered. So we've grouped the cases here for this presentation into 4 categories. So testing, restrictions, vaccination, and disclosing vaccination status. So on the subject of testing, testing of employees is going to be found to be generally reasonable. So in this first decision called Crescent Care Nursing, Retirement Homes, and Christian Labor Association, the arbitrator found that a requirement that employees be tested every 2 weeks for COVID-19 was reasonable. And this was because the risk of controlling an infection in a place where the elderly were outweighed the minimal intrusion of a test. In the decision below, in Unilever Canada, a food manufacturing facilities policy requiring all employees be tested every week was found to be reasonable. And the arbitrator concluded that this was the case because it was prudent to exercise caution in a facility that was subject to food safety regulations. In the next case here with Ellis Dawn Construction, this was a case where the employer required everyone to be tested twice per week to enter the work site, also found to be enforceable. It was an essential service and workers routinely moved between job sites and employers. So this requirement was found to be reasonable. And then in OPG and the Power Workers Union below, again, testing unvaccinated employees every 2 weeks was found to be reasonable. So regular testing is going to be reasonable. Let's look now at restrictions. So in the decision of OPG and the Power Workers Union, the arbitrator found here that restrictions are generally reasonable. So even where physical fitness is a required aspect of the employee's position, that restricting access to the employer's gyms and fitness facilities only to vaccinated employees was reasonable. And this was because the arbitrator found that gyms were high-risk areas for transmission, and that vaccination is required for the same reason that Ontario requires patrons of public gyms to be vaccinated. Vaccination will depend on the circumstances in terms of whether or not the policy will be reasonable. So we've talked a little bit about the Human Rights Code exemptions. The Human Rights Commission, which comes out with policies which interpret essentially what the Human Rights Tribunal is doing and comes out with opinions as to essentially how human rights laws should be applied, commented that a person who chooses not to be vaccinated based on personal preference does not have the right to accommodation under the code. So mandating vaccination is likely to be reasonable where the risks are high and vulnerable populations require protection. It's likely reasonable when necessary to comply with an existing contractual relationship, such as an employment agreement, collective agreement, or lease. And in contrast, though, mandating vaccination may be unreasonable where practical alternatives exist, such as working remotely, working outside only, and physical distancing, masking, screening, and testing, the usual sorts of things. In the decision here of Electrical Safety Authority and Power Workers Union, an employer requiring all employees to be fully vaccinated or subject to discipline was found to be unreasonable in this case. And this was because the vast majority of employee work, according to the arbitrator, could effectively be conducted remotely. And that was an acceptable alternative to having the majority of workers come back in person. Now, a couple of notes here. The arbitrator was careful to specify that the decision should not be seen as vindication for those who chose to remain unvaccinated. And the decision also acknowledged that there could be circumstances when requiring all employees to be fully vaccinated would be reasonable. In the cases here at Bunge, Hamilton, Canada, a vaccination policy for an agricultural supplier was found to be reasonable. And this was the case because the policy was necessary to prevent material interference with business and to comply with the terms of its lease from a federal port authority. And then in UFCW and Paragon, the mandatory vaccination policy was upheld on the facts of this case. So first of all, the security company's clients, many of them required the security guards to be vaccinated. So it was necessary to comply with those contracts. And also there happened to be an article in the collective agreement which mandated employees to agree to vaccinations if they were required to attend at a particular job site, which was a pretty important fact in this decision. In Power Workers and Lexicon, the employer required all employees to be fully vaccinated or to attend an educational program. And if they didn't, they'd be placed on unpaid leave. The policy was found to be reasonable as it applied to most employees, but it was found to be unreasonable for employees who worked exclusively from home or exclusively outdoors. So that's where the arbitrator decided to draw the line in terms of reasonableness in this case. Disclosing vaccination status, or a requirement for employees to disclose their vaccination status, is likely to be reasonable as long as the employer takes appropriate steps to maintain the confidentiality of the information. And there's two cases which address that issue. This is a case about an employee who worked at Scotiabank Arena for not disclosing his vaccination status, and the employee lost. The policy was found to be reasonable as well in this case. The purpose of a policy may affect its enforceability. There are a number of possible purposes that an employer can have when enacting their policy. So it could be things like improving health and safety, promoting vaccine safety education, improving attendance, or stopping the spread of COVID-19. Now, in light of the Omicron wave, an argument, I suppose, could be made that the policy would be unreasonable if the policy's purpose was to reduce the spread of COVID-19, because the variant is far more transmissible, and it's not so clear what having two vaccines will necessarily do. Now, it's expected that vaccines are nevertheless going to be effective in preventing severe outcomes. But I do want to take a look at something that the arbitrator in a Lexicon and Power Workers Union said in dealing with an argument about Omicron. So basically, the union said that the policy shouldn't be reasonable because of Omicron. It's just, no point. There's no clear objective. But the arbitrator essentially said no, and said, look, the employer doesn't have to establish with scientific certainty that there's going to be a cause and effect relationship, because we still don't know a lot for sure about this. The entire point is to take precautions as against the yet unknown. And so despite the argument about Omicron, the arbitrator still found a mandatory vaccination policy to be reasonable. Terminations for violating COVID-19 policies. So these are cases, employee was terminated in Garda for not self-isolating pending the result of a COVID-19 test. The employee was terminated and the arbitrator found it reasonable. And an employee here who was terminated in response to providing false answers to COVID-19 screening was also terminated, and the arbitrator found it to be reasonable as well, and that's the Liuna decision. And suspension, this employee in Ryam Inc. Forest was suspended for threatening to give his supervisor COVID by removing his face mask and pretending to spit in his direction, and a 2-month suspension was ultimately found to be reasonable. Before I end, I just want to comment quickly on what Service Canada is doing about employee eligibility for EI if an employee is terminated as a result of failure to comply with the employer's vaccination policy. So really the key here is if that happens, if you're terminating someone for violating a COVID-19 policy, you would use code M on the record of employment, but then Service Canada is likely to contact you as an employer to determine whether the policy was clearly communicated, whether the employees were informed that termination was a possible penalty for non-compliance, if the application of the policy to the employee was reasonable, which is the big one, that's what we've spent the last 15 minutes or so talking about, and then whether or not there were any applicable exemptions, which is really a reference to the Human Rights Code type exemptions. So these are important factors to consider when drafting a vaccination policy. We have written a blog which addresses all of the issues and goes into a bit more detail about some of them. This is the title of the blog here. It should already be published in our firm's blog on our webpage, and if not already, should be available through the firm's social media as well. So I would encourage you to read it. So that concludes the presentation on this topic. And I am now going to pass the floor over to my colleague, Tim Gindy, who will speak about worker classification. Tim, it's all you.